All right, good morning, everybody, or afternoon, depending on if you're in the morning or the afternoon class. I had to be called away for some issues. So today's class is going to be this video feed. We will cover everything. See if I can get this to how I want it to be. Today's class is going to be on chapter 14, consideration. So if you take a look at the outline that I've provided for today's class, we have, I think, 14 separate items that we're going to look at. One, what is consideration? Two, what is the benefit/detriment test? Three, is a promise of a gift an enforceable contract? Four, is love and affection valuable consideration? Five, will courts involve themselves in testing the adequacy of consideration? Six, must consideration be valued in money? Seven, what is an illusory promise? Eight, is a cancellation clause in a contract valid, or does it make the promise illusory or an illusion? Nine, are conditional promises valuable and enforceable? 10, is a pre-existing legal obligation consideration? 11, may a contract be modified without additional consideration from both parties? 12, when a compromise occurs and payment arrangements are changed, are they enforceable? Is there consideration to support the changes? 13, is past consideration valid for a new contract? And finally, 14, what are exceptions to the need for consideration in a contract? Okay, so that being the case, let's go take a look at what the book has to say about some of these things. So let's start with consideration. What is consideration? Give me a second to move some things around on the screen here. Okay, consideration is a, be careful before you move things. Consideration is a promise or performance that the promisor demands as the price of the promise. Okay, so consideration is the bargain for exchange between the parties to a contract. In order for consideration to exist, something of value must be given or promised in return for the performance or promise or performance of the other. The value given or promised can be money, services, property, or the forbearance of a legal right. Okay, so consideration is what you give up in order to get the promise from the other party. All right, so go promisor, promisee type thing here. The promisor, I'll give you $5,000 if you paint my house. Okay, so my promise is to give you $5,000. Okay, the exchange back, the return promise is I will paint your house for $5,000. Okay, so a promise for a promise. I'll pay you $5,000. I will paint your house. Okay, we know we need more details in there, but let's keep it as simple as possible. Consideration, something of value that is bargained for. I will exchange something of value to you if you give me something of value back. Now, value, consideration. I will pay you $5,000. Now, there's a dollar sign in front of some numbers there, right? $5,000. It's easy to see value there. It's easy to see consideration. It's just there. Okay, consideration is something of value. There's a dollar sign in front of 5000. So is that valuable? Is that value? Yes. Would that be consideration? Yes. All right. The backside of that, I will paint your house. Okay. Now, that doesn't have a dollar sign in front of it, but does that promise carry value? Okay, going back to what the book said, the promise can be money, services, property, or the forbearance of a legal right. Okay, so money was on the first side. I'll pay you $5,000. I will paint your house. That's services. Okay, obviously that's a service that I'm paying for, the service of you painting my house. So service can be valuable consideration. Exactly what we do every day. You know, anybody that has a job, you are getting into a contract with your employer on a daily basis. I will pay you $10 an hour if you give me your time. I'll give you my time. Your time has value. It's really the most valuable thing that you own. Okay. So I just want to harp on this for a minute. Value can consist of money. Okay. We just talked about the dollar sign. Services. Yes, your time or services or your expertise is indeed valuable. Property. Can it be property? I'll give you $5,000 for that Rolex watch. Yes, I'll give you this Rolex watch for $5,000. Well, there you have it. It's an exchange of money. We're not going to argue that that's valuable consideration for property, the watch. Okay. Now, the last one in the list is a little bit harder to see because it's the forbearance of a legal right. And so if you have a legal right to do something and you are going to give up that right, then it is valuable consideration. The easiest place to see this is if you have a lawsuit or a dispute between parties and they don't want to end up going to court. So what they do is they enter into settlement negotiations. All right, I'm suing you for $10,000. Well, do you really want to go through the trouble of suing me and trying to prove everything? You've got a chance you're going to lose. I don't want to put forth all the effort to defend this lawsuit. I consider this to be a nuisance, and I'm willing to pay some money just to make it go away. I'm not going to admit any kind of faults, but I will pay money just to see it go away. Okay, so when you're entering into negotiations for the settlement of any kind of a dispute, one party is giving up a legal right generally. Okay, here's one for you. I am in Giant Eagle and I slip on a grape. Okay, and I am injured, broke my ankle. I've got medical bills. I've got lost wages. I've got pain and suffering. So I hire a lawyer. The lawyer approaches Giant Eagle and they say, listen, we have the right to sue you. We will sue you. However, if you give us $10,000, we'll just go away. Okay. Now, Giant Eagle, if they decide to settle this, is going to be giving up $10,000. Well, there's your dollar sign. So you could obviously think that this is indeed going to have value, at least on Giant Eagle's side. But what about on my side of this contract? What am I giving up? Well, I'm giving up the right to sue. I could go into court. I could file a lawsuit, and we could have our trial and determine whether or not Giant Eagle is responsible for my injuries, and also decide what the value of my claim is going to be. I'm giving up the right to go to court. Okay, that's a forbearance of a legal right. I'll give you another example of this just to make sure that you understand it. One of my sons. First off, you have to understand my father was in World War II, and as a result of spending some time in combat and whatnot, he ended up a smoker because everybody in the military smoked in World War II. He became a heavy smoker. My dad died of lung cancer. I'm very anti-smoking because I watched my father suffer with that. Well, one of my sons smokes. He's over 21, and I don't want him to smoke. So I tell him, I say, Eric, I'll give you $500 if you can give up cigarettes for 4 months. Not smoke a single cigarette for 4 months. I'll give you $500. Now, dollar sign on my side, right? 500 with a dollar sign in front of it. There's obviously value there. What's the consideration being put up on the other side by my son? Well, he's going to give up smoking in order to make this contract legit. All right, so he gives up smoking. Well, where's the value there? Is there any real value in that, Professor Gamalchak? Yeah, there is. Because, see, he's over 21. Cigarettes are legal He has a legal right to smoke cigarettes. He's going to give up that legal right in order to earn the $500 that I'm willing to give him. So consideration can be, once again, I'm just going to repeat it, money, services, property, or the forbearance of a legal right. All right. The next thing I have on the outline is the benefit detriment approach. Okay, so that's the next thing that's really in the book there. Some jurisdictions analyze consideration from the point of view of a benefit detriment approach, defining consideration as a benefit received by the promisor or a detriment incurred by the promise. Okay, so if you look at it from the fact that, oh, I'm going to get a benefit and you're going to have a detriment, that is one way of looking at consideration. Not particularly fond of that approach, but it does exist. All right, gifts. The next thing in the chapter is about gifts. Is the promise to make a gift, is the promise to give a gift an enforceable contract? All right, so one of the most precious things that I own is a pocket watch that belonged to my grandfather. Not that it's solid gold or it's a particularly wonderful, rare, super expensive brand. Yeah, it's just a pocket watch. My grandfather worked as a conductor at the Pennsylvania Railroad for a while in the early 1900s, and that was his watch. Okay, when he died, it became my father's, and I remember seeing it in my father's dresser. And I said to him, I said, Dad, I'd really, really like to have that watch. I'd like to have my grandfather's watch. And my father said, yeah, no problem. We'll see about it. Yeah, I'll tell you what. Yes, I'll give you that watch. Okay. And so let's say that a year later, I go to my father and I say, okay, I'm ready to take that watch now. And my father says, you know what? I changed my mind. I'm not going to give it to you. That would be unfair to your brother. He's your older brother, so he really should get the first choice of the family valuables. My father promised me the watch. Isn't that a contract? Well, the problem here is that in order to have a contract, we have to have a promise for a promise. Benefit and a detriment, right? All right, so the promise of the watch, property, right? So property can be consideration. So yes, my father's promise to give me the watch was indeed consideration. But what was my consideration? What was my return promise? There wasn't one. This was going to be purely a gift. See, and what makes a gift easy to see is that there's only consideration on one side. Even if you go back to the unilateral contracts that we talked about, I'm going to give a reward to somebody who finds my lost dog. There were two sides to that. There was consideration on both sides. I'll give the $100 reward, obviously, $ value. Well, what's the promise on the other side? Well, there was no promise. It was an action. That's what made it a unilateral gift. Excuse me, unilateral contract. But when the person brought the dog back to me, that was consideration. They brought back my property. Okay, so there's even in the unilateral contract, there's consideration on both sides. Only one promise, but still consideration on both sides. In a gift, there's no return. There's no return promise. If I would have promised that I was going to give up smoking, or if I was going to promise to get straight A's in school, or something, then there would have been some consideration theoretically on the other side. But purely giving a one-sided promise with one side with consideration. Gift, it's a promise to make a gift. It is not enforceable. Now, I know that you are all worried about this. The way that it worked out with the watch was this is just a story. My father never said no. My father said that he wanted to keep it while he was alive. My father died. It then became my mother's property, and my mother then gave it to me. So I do indeed have that watch that I talk about. While we're in gifts, there's one type of gift that does have the ability to be enforced, charitable subscriptions. Okay, so this is a special type of a gift. This is where you promise to make gifts to a particular charity. It's called a subscription because oftentimes charities will put together a long-term project and they're asking people to commit over the long term. You'll see this where colleges, universities, churches will do this if they have specifically if they have like building projects going on. So church that I go to, they went through a building phase a few years ago, and they needed millions of dollars to put up these new buildings that they wanted. And so they decided they needed, let's say they needed to raise $5 million, and so they went out to the parishioners and they said, we need to raise $5 million, and we need it to come from you guys. Okay, so here's what we want to do: is we want you guys to pledge that you're going to make contributions for this capital project over the next 5 years. So rather than asking people to make a one-time massive donation, they were asking them for large donations over a 5-year period. That's what's called a charitable subscription. So if I wanted to give, say, $10,000 towards the building of this capital campaign, then I could have done it as $10,000 payment up front. They'd love that. Or $2,000 a year for the next 5 years. Okay, that's a gift, right? Church didn't give me anything back. There's no consideration on the church's side. But what's going to happen here is we're going to end up with an enforceable promise to pay the church for the charitable subscription. All right, the next thing on the outline. Is love and affection valuable consideration? Okay, love and affection. Think about that. Many times you will receive something of value because of somebody's love and affection. But the reality of it is that love and affection is a reason for making a gift. It is not consideration. An agreement to give property for the consideration of love and affection does not transfer to the property to the donee, nor secure for the donee a right to sue to compel the completion of the contract. Love and affection alone has not been recognized as consideration to a contract. All right. The next thing that I have on the outline here is will the courts involve themselves in determining the adequacy of consideration? Okay, so I will give you, whoops, that's the wrong button. I will give you $5,000 for your car. Okay, well, it depends on what the car is, right? If you decide that you are just absolutely in love with the 1964 Chevrolet Corvair, notice I didn't say Corvette, I said Corvair. The Corvair was a two-seater with a pancake engine in the back. It was actually the subject of Ralph Nader's book, Unsafe at Any Speed. It was considered, according to Ralph Nader and his group of protectionists, the worst car ever made, the most dangerous car ever made. And so as a result, they stopped production. It's not considered to be a really great car, but it is kind of rare, so you could consider it to be a collector's item. So is $5,000 for a Corvair a decent price? Probably, might be about right. I don't know. It could, maybe it's not enough because Corvairs are so rare. Like I said, but it's not a really cool car that people are demanding or really wanting. Take it beyond that. What if I say I'll give you $5,000 for your car, and it is a 2020 Rolls Royce, and you decide to sell me your Rolls Royce? Okay, do we have consideration? Well, we have consideration on the one side. I'll give you $5,000 for your car, and you say, yes, I'll give you my car for the $5,000. That's a great deal for the one party and a really lousy deal for the other party. If we were to have a dispute over this, there's a lot of things, and we'll talk about something called unconscionability later on in the course. But short of something, in the level of fraud, the court will probably just say, you know what, you decided to make that deal, and we will enforce it. So the courts generally don't like to get involved in trying to determine whether it was adequate or not. Okay, so just let that be part of what we talk about. What's next? Must consideration be valued in money? No, certainly not money. What did we say? Money, service, property, or forbearance to not exercise a legal right. Okay, so okay, on page 265 in your textbook, forbearance is defined as refraining from doing an act. Most cases, consideration consists of the performance of an act, such as providing a service, or the making the promise to provide a service or goods, or paying money. Consideration may also consist of forbearance, which is refraining from doing an act that an individual has a legal right to do, or it may consist of a promise of forbearance. In other words, the promisor may desire to buy the inaction or a promise of inaction of the other party. Giant Eagle is going to give me $10,000 if I don't sue them. Okay, so they gave me the $10,000 and I agree that I will not sue them. Now, the reality of it is we're not going to just have a handshake on something like this. There will be a legal document that's drawn up. It'll be called settlement of lawsuits or giving up of rights. It'll be some sort of a document like that where I will sign saying that in exchange for $10,000 paid by Giant Eagle, I agree to not sue. And I give up all of my rights to sue. That way, if I go back on my promise and I actually take the $10,000 and then turn around and then sue them, all they have to do is bring the contract, and it will be a contract, to court. The court will determine whether the contract is valid or not. Okay. Is there a promise for a promise? Yes. Was there an offer and acceptance? Yes. Is it in the right form? In this case, it's in writing. It really didn't need to be in writing, but you have to have it in writing to prove that the agreement is there. Is there adequacy of consideration? Well, the court's not going to look at whether it's adequate to pay the $10,000. It should Giant Eagle have paid more? I don't know. But the courts aren't going to care about that. Is there consideration on both sides? Last question. So consideration on Giant Eagle's side, $10,000. There's your dollar sign. Easy to see value. Easy to see that there is indeed consideration. However, on my side, what's the consideration that I am putting into the deal? Forbearance. I'm not going to sue because I've received the settlement money. Okay. Now, the next thing that is on my outline is what is an illusory promise? Okay. An illusory promise, definition according to the book, it's a promise that in fact does not impose any obligation on the promisor. In the bilateral contract, each party makes a promise to the other. For a bilateral contract to be enforceable, there must be a mutuality of obligation. Both parties must have created obligations to the other in their respective promises. If one party's promise contains either no obligation or only an apparent obligation, this is an illusory promise. And because it's not really a promise, it doesn't have any value. If it doesn't have any value, it can't be consideration. So if you have only an illusory promise, then you do not have a consideration. Okay, there's an example. Jacksonville Fire soccer team contracted with Brazilian soccer star Edmundo. Edmundo signed the contract to play for Jacksonville in the new International Soccer League for 5 years at $25 million. This extensive document signed by Edmundo set forth the details of the team's financial commitment and details of Edmundo's obligation to the team and its fans. On page 4 of the document, the team inserted a clause reserving the rights to, quote, to terminate this contract and team obligations at any time in its sole discretion. End quote. During the season, Edmundo received a $40 million offer to play for Manchester United in the English Premier League. He left because Jacksonville had a free way out of the obligation by its unrestricted cancellation provision. It made its promise to Edmundo illusory. Edmundo was therefore not bound by the Jacksonville contract because of a lack of consideration. Okay, so take a look at that. They agreed to pay him $25 million if he were to play for the team for 5 years. All right, that sounds good to me. It sounds like we've got his services on one side, we've got money with a dollar sign on the other side, we have consideration on both sides. However, with the dollar signs on Jacksonville's side, it said, we will pay you $25 million. However, we reserve the right to cancel this contract at any time for any reason. Well, does that mean that Edmundo is going to get his $25 million? No. It means that the team has reserved an absolute right to void this contract, and as a result, their promise is an illusion. So let's say that they missed a paycheck to him, and he sues them, goes into court, and he says, Your Honor, they didn't pay me my $5 million for this year. I demand that they be required to pay it. And Jacksonville comes into the court and says, well, we really didn't have any obligation to pay him because we had the right to void this contract at any time. So we're telling you now, we're voiding the contract and not going to pay him. There's no absolute requirement that they do what they said they were going to do. Therefore, not consideration. It's an illusory promise. Which leads us to the next thing. What about contracts that have what I'll refer to as contingencies in them? These are what are considered to be cancellation provisions, okay? So cancellation provision, a crossing out of a part of an instrument or a destruction of all legal effect of the instrument, whether by act of party upon breach of the other party or pursuant to agreement or decree of courts. So is a cancellation provision automatically an illusory promise? Maybe not, okay? The Jacksonville situation with Edmundo was very much an illusory promise because Jacksonville had all of the power, all right? Let's say that the contract read that they would pay him $25 million for 5 years worth of service. However, in the event that Edmundo received a career-ending injury through any source, either on the field or in his personal life, that they would have the right to terminate the contract upon the documentation of said career-ending injury. Okay, that's a cancellation provision. Now, is it entirely up to Jacksonville as to whether the $25 million is going to get paid? No. There's a contingency out there that is not within Jacksonville's sole control. Okay, so if Edmundo ends up with an injury, he ends up breaking his leg in a very severe fashion, where it's considered that he would never be able to effectively play soccer again. That's something that Jacksonville didn't do. Yeah, it happened when he was playing the game, but Jacksonville didn't have any control over it. Let's say he's in a automobile accident. He's got all this money and buys himself a fancy Lamborghini, and he's driving at 150 miles an hour and gets into an accident and ends up with his legs being amputated. Obviously, it's going to be hard to play soccer if you don't have any legs. The example they give in the book is actress Zsa Zsa Gabor. And Zsa Zsa Gabor, if you were a little bit older than you are, you would understand who she is. She was an actress in the 60s and 70s, basically. Made a contract with Hollywood Fantasy Corporation to appear at a fantasy vacation in San Antonio, Texas on May 2nd through 4th for a $10,000 appearance fee, plus a bunch of extravagant expenses. The last paragraph of the agreement stated, it's agreed that if a significant acting opportunity in a film comes up, Ms. Gabor will have the right to cancel her appearance in San Antonio by advising Hollywood Fantasy in writing by April 15, 1991. Ms. Gabor sent a telegram on April 15, 1991, canceling her appearance. During the May 2nd through 4th period, Ms. Gabor's only activity was a 14-second cameo role during the opening credits of Naked Gun 2.5. In a lawsuit for breach of contract that followed, the jury saw this portion of the movie and concluded that Ms. Gabor had not canceled her obligation on the basis of a significant acting opportunity, and she was held liable for breach of contract. So that's an illusory promise. That's a cancellation promise. The next thing that I have on my outline here are conditional promises valuable and enforceable? So conditional promise is the next thing that we want to look at. A conditional promise is a promise that depends on the occurrence of a specified condition in order for the promise to be binding. The example, Mary Sparks, in contemplation of her signing a lease to take over a restaurant in Marina Bay, wanted to make certain she had a highly qualified chef to run the restaurant's food service. She made a contract with John Grumpy White to serve as executive chef for a one-year period at a salary of $150,000. The contract set forth his responsibilities and was conditioned on the successful negotiation of the restaurant lease with Marina Bay Management. Both parties signed it, although the happening of the condition was within Mary's control because she could avoid the contract with Grumpy White by not acquiring the restaurant lease. She limited her future options by the contract with White. Her promise to White was not illusory because after signing the contract with him, if she acquired the restaurant lease, she was bound to hire White as her chef. Before signing the contract with White, she was free to sign any chef for the position. This contract is enforceable. Okay, so conditions. Okay, so you have a conditional promise. I guess in reality, we had talked about best efforts before. If the contract would have had that condition in there, that she would not be responsible to pay him anything if she didn't get the lease. I guess if I were Grumpy White, I would have said that I want there to be a best efforts clause in there saying that you're going to make best efforts to get the lease. That way, if she just stops because she decides she doesn't want to do it, she's not making best efforts, and therefore I would probably get my money. Best efforts means she was continuing trying to negotiate the lease and all of the things that go along with that. All right. The next thing here is a pre-existing legal obligation. If I have a pre-existing legal obligation, is that consideration? Ordinarily, doing or promising to do what one is already under a legal obligation to do is not consideration. Okay, so here we are. I am a policeman in the city, and the city police department has decided that what they want me to do is they want me to start walking a beat in the business district at night. Instead of driving around in my car, I'm going to be on foot, and I'm going to be walking through the downtown business section of town. I'm going to be rattling doors and shining my flashlight in store windows and things like that. This is something that the city has decided that they want to do in order to try and reduce the amount of thefts that are happening overnight in the business district. So after I have been informed that this is my new job, during the day I go around to the various businesses and I say, hey, here's something I can offer to you. If you give me, say, $100 a week, I'm going to promise you that 5 days a week, 5 nights a week, I'm going to walk past your business a couple of times during the night. I will check your doors to make sure that they are locked. I'll shine a flashlight in the window and look to see if there's anything strange going on in your business. And obviously, if there's something going wrong, I will apprehend the offenders and protect your business and your property. So the people say, hey, that's great. So a bunch of people agree that they're going to pay me, the police officer, $100 for doing all this stuff. Is this an enforceable contract? What if one of the people decides they don't want to pay me anymore? Well, I already have a pre-existing legal obligation. That's my job. I'm already being paid by the city, by the police department, to do exactly what I said I was going to do for you. It's not enforceable. There's not any legitimate consideration. It is only the um, the carrying out of my already pre-existing legal obligation. All right. May a contract be modified? Oh gosh, that's not what I wanted to do. Push the wrong button there. Here we go. Can a contract be modified without additional consideration from both parties? Okay, so modifying a contract. Where is that in the book? Let's just get past it. Excuse me, I have to go back. Waiting for things to load. Okay, where you see this a lot is what happens if I'm a contractor. You're going to see this happen a lot with contractors. I'm going to contract with you to put an addition onto your house. Let's say $20,000. I'm going to put an addition onto your house, and we've gone through all kinds of things in order to make sure that we have the plans right. Everything has been chosen, colors, everything. Okay, and I'm building this addition onto your house, and you're looking at it and you're thinking, wow, this is really coming out wonderfully. I should have probably made a few other changes, made it a little bit more fancy. I want better windows and a better door. So you come to me and you say, listen, what I want to do is I want to change the contract. I want to put on better doors and better windows. And I think about it and I look at the extra, increase in price to myself and I go, okay, I'll do that, but it's going to cost an additional $5,000 to change the windows and doors to what you want. And you say, great, great, absolutely. All right. Is that a enforceable contract? Well, in theory, it is, because is there consideration for the change in the contract? Okay, so we have an original contract and the price is $20,000. But you come to me and you say, I want to change the contract and you want these better doors and windows. Okay, so consideration on my side, I'm providing better product. Consideration on your side, I'm asking you to pay an additional $5,000. Okay, so that's actually good. That contract would be enforceable. You're going to find out in the real world, though, that if you didn't get that in writing, you're not going to win as the contractor. Okay, if you ever have a contract in place and your customer, your client, the other party decides they want to change the contract, generally with the change, the adjustment will be legal. However, the proving that happened is going to be the problem. They're going to refuse to pay, and it'll be difficult for you to win that in court. Okay, so rule number one, make sure you get that in writing. All right, give me a second here. I'm going to pause just for a second. I'll be right back. All right, sorry about a small little pause there. All right, so now we want to talk about, I believe the next thing on the outline here is compromise. Yeah, it's called a compromise and release claim. Here's your situation. What if you have a debt? You are supposed to pay somebody back $40,000, and you have let's say it's a debt that you owe. You borrowed money and you can't pay it back, and you are trying to get into negotiations to try and deal with that. Okay, so a lot of times the creditor will say, here's what we'll do, because the creditor realizes that at a certain point, they're spending money to not collect money from you. And You know, they can sue you. We can end up in court. But if you're not doing well, if you don't have a lot of assets to deal with, then there's a really good chance that they're not going to get anything. Okay, so it's called an empty judgment. So get an empty judgment is a waste of time and money. Um, so so oftentimes they'll decide to settle for less money than you owe them because they just want to get it dealt with. They don't want it to be on their books anymore, and they'd rather collect something than collect nothing. Okay, so that's a compromise and a release of claim. Okay, so the question here is, are they enforceable? Okay, because you have to take a look at the whether there's consideration on both sides of the contract. Okay, so the rule that doing or promising to do what one is already legally bound to do is not consideration. It applies to a part payment made in satisfaction of an admitted or liquidated debt. So if I owe $40,000 and I don't pay it, I don't have the ability to pay it, or I don't want to pay it, whatever it is, and I say, listen, I'll give you $20,000 and we'll call it even. That's not going to create an enforceable contract, right? Because there's no new consideration because I was already under an obligation to pay that 20. I was obligated to pay 40. But certainly I was obligated to pay that first $20,000 back. So pre-existing legal obligation is not consideration to a new agreement. Okay, so it said liquidated debt, admitted or liquidated debt. Liquidated debt is a debt that, and they don't give us a definition in the book here. Liquidated debt is debt that we can put a dollar sign on. Oftentimes, if you have a dispute over something, I manufactured 1,000 widgets for you at $10 a piece, and I sent you a bill for $10,000. But when you received them, many of the widgets were damaged, and I'm after you. Pay me the $10,000 that you owe me. Pay me the $10,000 that you owe me, and you're saying, no, I don't owe you $10,000 because some of the widgets were damaged, and we refuse to pay for the damaged widgets. We can't use them, so they're of no value to us. So let's say that a couple hundred of let's say 200 of the widgets are damaged. So you are willing to pay me the $10,000 for the $10 a piece for the 800 that are good, but you refuse to pay for the other 200. So you say, I will give you $8,000 if you shut up about this. If I accept the $8,000, is that an enforceable contract? It is, because what we had was not a liquidated debt. It didn't become a liquidated debt until we actually put a number on it. When we agreed that there were 200 widgets that were damaged and completely unusable, then it turned everything else into it made that not part of the agreement. So therefore, when we made the liquidated number of 8,000, that was the number. And if I paid the 8,000, it completely satisfied the debts. Okay. Let's see, examples in the book. John owes Mark $100,000, which was due on March 1st, 2016. On March 15th, which is 15 days too late, John offers to pay back $80,000 if Mark will agree to accept this amount as discharge of the full amount. Mark agrees to the proposal and set forth in writing, signed by the parties. However, Mark later sues for the $20,000 that's remaining. Mark will be successful in the lawsuit because John's payment of the $80,000 is not consideration for Mark's promise to discharge the full amount because he had a pre-existing legal duty to do so. What if we change it a little bit? What if I owe the money and it's due on March 1st, and on February 1st, a month early, I realize I'm not going to be able to pay it back. I contact you and I say, listen, I'm not going to be able to pay that $100,000 back. There's really very little chance I'll ever be able to pay that $100,000. I'm willing to give you 80 right now if you'll just go away. Would that be enforceable? That would be enforceable. The reason for that is we would have consideration on both sides, okay? The consideration on the lender's side is that they would agree to take $20,000 less, $ value. On my side, I am paying the debt on February 1st when it's not due until March 1st. So I am paying it early. That is consideration because I have the legal ability, the legal right to wait until March 1st to pay. By foregoing that or forbearing the additional month of holding the money, the fact that creates consideration. So now we would have consideration on both sides, and it would be considered to be valuable consideration. Okay, yeah, the debtor and creditor can have a bona fide dispute over the amount owed, even as to whether any amount is owed. That's called unliquidated debt. In this case, payment by the debtor of less than the amount claimed by the creditor is considerations for the release and settlement of the claim. So that's what I talked about when we talk about getting a liquidated debt. There's also another thing out there which is called composition of creditors. If you were to declare bankruptcy, what would happen is your debt that is secured. That means like mortgages on your house and car loans where they're keeping the title. You know, they're secured. Whereas if you don't pay the debt, they get to take the asset. They get paid, or they take the asset, one or the other. But the other types of debt that you have out there is what's called unsecured debt. And if you go into bankruptcy, all of your unsecured creditors will be put into a pool, and then they'll total up whatever the money is that's there. And then what they'll do is they'll see how much money you have available to pay those creditors, and then they'll just divvy it up. So if you had $100,000 worth of debt and you had $10,000 in the bankruptcy to pay those debts, then everybody would get 1/10 of what they're owed. So if you owed me $1,000, I would get $100. Composition of creditors is basically doing that, but without the bankruptcy court's oversight. It's agreement among creditors that each shall accept a part payment as full payment in consideration of the other creditors doing the same. So the consideration here is the creditors are willing to work together, and everybody is giving up their claim if everybody does this. Past consideration. Something has been performed in the past, which therefore cannot be considered consideration for a promise made in the present. Okay, so if you did something in the past, just like we were talked earlier about a pre-existing legal obligation, if you had past consideration, it wouldn't be valid for a current or a present promise. Okay. Example, Fred O'Neill came up with the idea of the formulation of a new community bank of Villa Rica and was active in its formation. Just prior to the execution of the documents creating the bank, the organizers discussed that once the bank was formed, it would hire O'Neill, giving him a 3-year contract in inflation-adjusted figures of $104,000 for the first year, $107,000 the second year, $110,000 the third. In a lawsuit against the bank for breach of contract, O'Neill testified that the consideration he gave in exchange for the 3-year contract was his past efforts to organize the bank. The court said, sorry, past consideration is no consideration. So he did not get anything out of that. He did not win his lawsuit. Other things that the book has as we move our way toward the end of the chapter here, moral obligation. A moral obligation is not consideration. Example, Robert Lewis and his brother Lewis Lester, had an agreement under which Robert would provide for his uncle Floyd and serve as his power of attorney, and the brothers would split the uncle's estate equally. Floyd left his estate to Lewis. Robert's suit against his brother to enforce their agreement failed for lack of consideration. Service performed by one family member on behalf of another family member are presumed to have been rendered in obedience of a moral obligation without expectation of consideration. of compensation. So therefore, since it was only a moral obligation, no contract. All right, so the last thing that I have on the outline is exceptions to the law of consideration. Just making sure what it actually says. What are the exceptions to the law of consideration? Okay, the need for consideration. So exceptions. Charitable subscriptions, we talked about that already. Okay, so if you're a charity and you are asking people to make contributions over a period of time, you subscribe to the continuing obligation to make payments, that is enforceable. The Uniform Commercial Code has some opportunities where a new consideration is not required. So we're not going to talk about the UCC right now because we're going to spend a lot of time on the UCC in a few more weeks. Promissory estoppel. Under the doctrine of promissory definition, a doctrine that a promise will be enforced, although it is not supported by consideration, when the promisor should have reasonably expected that the promise would induce action or forbearance of a definite and substantial character on the part of the promised. And injustice will be avoided only by enforcement of the promise. Okay. Doctrine of detrimental reliance, it's also called. 1, the promisor makes a promise that lacks consideration. 2, the promisor intends or should reasonably expect that the promisee will rely on the promise. 3, the promisee in fact relies on the promise in a definite and substantial matter. And 4, enforcement of the promise is the only way to avoid injustice. Let's see. She gives an example here, hopefully. Not necessarily. This is another one of those situations where you really have to be aware of what you have going on here is you're in equity. Okay, this is another time when we're going to be asking the court to enforce it or to flex its equitable muscles. Okay, so I made a promise that I would give you $1,000 if you did something. I don't know what, but what you were doing was not new consideration. Let's say it was old consideration or a legal existing legal obligation. But you relied on my promise, and I knew that you would rely on my promise. And because of the fact that you relied on it, you put yourself into a position where if I don't keep my promise, you will be harmed in a very extreme manner. That is detrimental reliance. That's promissory estoppel. The equitable court will step in. All right, so what we have here is chapter, I don't know, what was this, chapter 14? It was the chapter on consideration. I'll be back in school on Tuesday, so we'll continue on with contracts. Remember, next week you do have another homework assignment that's due. Beyond that, have a great weekend, and we'll see you on Tuesday. Find the off button here. All right, everybody.